Okay, thank you all for being here. I'm Judge Ruben Castillo, the Chief Judge of this district, and we're honored to host the second part of the Seventh Circuit Bar's program on redistricting. The first part was on the history of the Voting Rights Act, and now we're going on to meatier and juicier issues of redistricting, racial and partisan gerrymandering. I want to thank our panelists for being here. We're happy to host the third part of this series, so stay tuned. I think the date's going to come out fairly soon. It's going to be a January date, as I understand it. I've had the pleasure of litigating redistricting cases, so I'm anxious to hear about earmuffs, snakes, and hatchet-wielding poodles. Beauty is in the eye of the beholder, so they say, as with art. But in all seriousness, I can't think of a topic that affects so much. I mean, when we're talking about the topic of racial, partisan, gerrymandering, just think, every piece of federal or state legislation goes through a legislative body, and ultimately, whatever our views might be on any piece of legislation, whether it be such topics as immigration reform or gun violence, two topics that I'm pleased to say the Seventh Circuit Bar has addressed in recent symposiums. Whatever our points of view are on those are all affected by the critical issue of redistricting and gerrymandering. This really goes to the heart of two concepts, that is responsiveness to voters and the overall competitiveness of any legislative district. It has been said that because too many of our legislative districts are not competitive, it's really a threat to the heart of our democracy. So my job is to get out of the way of this vital discussion of redistricting, to welcome this critical discussion, and I can't think of anything that's more timely in light of the October 3rd Supreme Court argument that was heard in the Wisconsin case of Gill versus Whitford. So we'll go on with the panel, and I'm pleased to turn it over to our very capable moderator, Laura McNally, who will introduce our panelists. Laura.
Thank you, Judge. I'd like to introduce you to the panel who are going to be giving a good overview of the legal issues in racial and in partisan gerrymandering, as well as some of the social science that is coming up to really dig into the partisan gerrymandering issue. So our panelists today, Mark Elias, who you might have seen on the flyer, was unable to make it. He had to be in court in New Jersey today. But we have Nina Perales here, who is she's the Vice President of Litigation for the Mexican American Legal Defense and Education Fund. You might have heard of it as MALDEF. In that capacity, she oversees litigation across the country on voting rights issues, redistricting issues, anti-immigration issues. In the area of voting rights, she was lead counsel for the Latino voters in the Lulock versus Perry case in 2006, as well as other cases that have made it through up to the Supreme Court, including the Gonzalez versus Arizona group of cases. She has also testified in Congress on issues relating to voting rights, including before the Senate Judiciary Committee. So we're going to start off with Nina talking about racial gerrymandering. Then we're going to move on and speak with Ian Gershengorn, who will talk to us about partisan gerrymandering. Currently, Ian is the chair of this appellate and Supreme Court practice at Jenner & Block since September. But before that, he was in the Solicitor General's office and the federal programs branch of the Department of Justice. From 2009 to 2013, he was Principal Deputy Assistant Solicitor General. And then he was in the federal programs group. From 2013 to 16, he was Principal Deputy Solicitor General and then became Acting Solicitor General after Donald Verrilli left the office. In that capacity, he oversaw a wide variety of these redistricting challenges, including some of those that we're going to talk about today. He's going to give us the kind of legal framework, which is different for partisan issues. And then finally, we're going to hear from Nick Stephanopoulos, who is an important counsel and as well as thinker on the partisan gerrymandering issue. He was co-author of the efficiency gap, which is a social science metric used to evaluate partisan gerrymandering. And he's also counsel of record in the Gilwer versus Whitford case, which was argued in the first week of this Supreme Court term. So let's kick it off with the racial gerrymandering topic, and Nina.
Thank you very much. Thank you for the introduction. Thank you, Judge Castillo. It's a pleasure to be here today with you. I am the person standing between you and the discussion of partisan gerrymandering. But there is a reason that I'm going first, because in some ways I'm presenting a more historical perspective on gerrymandering in general. As you heard from the introduction, I work for MALDEF, which means my voting rights cases are largely on behalf of Latino voters. And so I'll talk to you a little bit about Latino voters and voting rights litigation and racial gerrymandering litigation. Latino voters are in a very interesting place right now in the United States because we're both looking back to a past that largely involves not voting because of official and unofficial mechanisms like school and housing segregation, employment discrimination, and official mechanisms like the poll tax and the literacy test and other laws that were passed throughout the Southwest purposely to make sure that Latinos, primarily Mexican Americans, were not voting. So for example, I do many of my cases in Texas, where Texas, although it didn't have a literacy test like Arizona did, it had a poll tax. And if you were poor and you had to decide whether you were going to spend your $1.75 on your poll tax or on buying shoes for your kids, you can imagine how that decision came out. And I've met people who saved their parents' poll tax receipts because it was such an important thing for their parents to pay the poll tax and be able to vote, for those few who did. So we look to a past where a lot of Mexican Americans were formally or informally disenfranchised, and also the subject of district line drawing that tended to dilute the vote back in the day. And then also looking forward into a period where there's a greater opportunity for registration and participation, even if the past didn't look like that, and also being in the position of being a very fast-growing minority group. What does that mean to be called a sleeping giant? You know, what are your obligations as a member of the sleeping giant? I have a former client who goes around with voter registration forms in the trunk of her car. Her car is a terrible mess, but one of the things about her car is she has a lot of voter registration forms in the trunk, because whenever she's at any family event at all, if she finds somebody who isn't registered to vote, she goes out to her messy car and gets the voter registration form. So that's the way she carries out her thoughts about being a member of what's called the sleeping giant. So if I can get this right, if I go forward once, you will see a map that just gives you a general sense, not the most recent, but a fairly decent map of the concentration of the Latino population in the United States. You can see lots of folks. You're looking for Chicago there, and you do see it's a little bit darker blue. The Northeast, look at Florida, but you can also see that there's probably the most population throughout the Southwest: California, Arizona, New Mexico, Colorado, Texas, of course, and up into the Pacific Northwest. This is what we were facing when we went into redistricting for the 2010 redistricting round, right? The census is taken in 2010, the data is released in 2011, and states have to redistrict not only their congressional lines, but also their state houses as well. This is Arizona, the red bar are Latinos. This is California. California didn't pick up or lose any congressional seats, but what was going on internally with California's population was pretty dramatic, with internal population loss and gains. So you can see there California got a lot more Latino over that decade. Texas, this can either be a really positive chart for you or a really negative chart for you, depending on how you feel about Latino voters. And this trend is one that, this is not just the picture from 2000 to 2010. We had a very similar chart for 1990 to 2000. So if anybody knows about what's called the J curve, those numbers are rising fairly rapidly. And this presents, of course, for elected leadership, the opportunity to either make a bid for Latino votes, encourage Latinos to go to the polls and vote for you because your issues are their issues, or to try in some kind of last gasp way to draw lines to dilute the Latino vote, right? This is another projection of Latino population trends in Texas. You can see the line crosses at a certain point, and Texas becomes more Latino than it does Anglo. Latinos are registering, they're starting to vote. I have a lot of pictures like this. I just saved one for you because Laura said pictures are good. This is some of the sort of representative artwork of how folks might feel about the growth in the Latino community in the Southwest and in the South generally. This is part of political responses. This is a website that is run by Texas Republicans. And the headline, which I might have been able to read, talks about...
It says the growing Hispanic population and the impact on Texas.
Race baiting is not the answer, right? And so you have folks kind of from all over the political spectrum saying, this is a new part of our state. We need to figure out what to do. And then there are people who like to draw lines to dilute the Latino vote because perhaps they consider it easier than reaching out to the Latino vote. So this is an email from the Texas redistricting litigation in which one redistricting lawyer is teaching another redistricting lawyer. One had been there working in the speaker's office for a while, the other one was new, and so he's telling him, this is what we want to do. We want to create a district that appears to be Hispanic, but we want to make sure that Hispanic registration and turnout is low enough in the district that Latinos cannot elect their candidate of choice. So we'll be able to call it a Latino district, but it won't actually perform as a Latino district. So he was very direct and he was being very instructive. And then the email got produced and all hell broke loose in the case. This was just one of the emails that we had. And so I'll give you an example of something that was done in Texas. This is one of my favorite pictures, this one and the one that comes after it. This is a congressional redistricting map adopted by the Texas legislature in 2011. You're probably wondering about that big blue district, and it's labeled District 26. It comes out of Denton County, which is very suburban and very, very conservative. And you'll notice that it has kind of we called it the lightning bolt, because everything has a nickname in redistricting. The lightning bolt goes down into that tan district. That's actually part of the same blue district coming out of Denton County, all the way down into the tan district. Those are all the Latino neighborhoods in the city of Fort Worth. So the Latino neighborhoods in the city of Fort Worth were combined with a much larger, much more conservative, largely Anglo population up in Denton County, which was not going to allow Latinos to elect their candidate of choice. Texas asserted a partisan gerrymandering defense and said, well, what we did here was we were just diluting the Democratic vote, right? There's a couple of hurdles to that. One is that not all Latinos, particularly in Texas, are Democrats. Quite a few are conservative and quite a few are Republican. But putting that issue aside, the defense here was, this is party, not race. So we went ahead, oops, that's the Democrats doing bad things. Let's go back, because you know I had to be even-handed about this. We turned on some additional data in our mapping software, and we decided to shade the Latino majority areas red and the African-American majority areas green. And you'll notice that that same lightning bolt that goes down into Fort Worth went in just specifically to scoop out Latinos. African-American voters were actually scooped out of Fort Worth and assigned to a different white majority district. So it was, in fact, a purely racial gerrymander. I have no idea why they thought that was a good idea, but there it was. The district court concluded that this was a racial gerrymander and it needed to be fixed. And now we have a different, as a result of an interim map, we have a different arrangement for our congressional districts in Dallas and Fort Worth. But I wanted to show you that because that's an example of racial gerrymandering to dilute the vote. The last example that I have for you, oh, it's really tricky to use this thing. Okay, there we go. So here's another situation that was actually also in Fort Worth. I don't know why in this decade Fort Worth was such a hotbed of racial tension, but here we are. It was a district that prior to redistricting had been trending very Latino. It was actually right on the cusp of being a Latino majority district, although it was represented by an Anglo. The Anglo incumbent was challenged by a Latino in 2012, and he won by only 159 votes. So he went in and he sliced and diced the Latino population in an attempt to try to hang on in his office, right? That's sort of a typical story. But in this case, both of these guys are Democrats. And the operative campaign and election was the Democratic primary. So here you have an example where a Democratic district was trending in the direction of Latino empowerment, and a Democratic incumbent who did racial gerrymandering in order to avoid that. And in fact, we just won a decision a couple of months ago that what had happened here was a racial gerrymander. One of the things that we showed the court was the next Latino challenger. He's the guy on the right. I'm sure you think that he looks pretty upright to me. I mean, he was a local businessman and all of that, but his Democratic opponent, the same guy who had done the racial gerrymander, put out a lot of flyers saying that the business that this Latino person owned was in fact a meeting place of the Latin Kings gang, right? And that his opponent in the primary, the Democratic primary, was a member of the Latin Kings gang, and how terrible it was, and how nobody in the district, which is a fairly urban district where people are afraid of gang violence, why it would be a terrible idea to vote for the Latino guy in the Democratic primary. The Latino guy won, by the way, by about 111 votes. So in this most recent election, that election, which was 2014, it did swing in the other direction. And the former incumbent is still out there saying that this guy is a member of Latin Kings gang. So that was, I believe that's the end of it. Thank you.
All right.
It's really quick. Okay. All right. Well, thank you. And while Laura plugs up, I think the first bit of my talk doesn't use the slides anyway. So thank you all for coming. It's really a pleasure to be here. And thank you again to Judge Castillo and to Laura for organizing, and for Nina and Nick for doing this. I'm going to do a couple of things. First, I'm going to start with a case from last term called Cooper v. Harris, which is it's similar to one of the cases that Nina alluded to. It's a racial gerrymandering case with a partisan overlay. And then I'm going to talk about Gill, which is the case that was argued on partisan gerrymandering this term that we're all waiting for. So what happened in Cooper? So Cooper is a case up from North Carolina, and it's a sort of serpentine district in the middle of the state that's been before the court a significant number of times. This is actually its 5th appearance before the court. And the allegation in the case was that the Republican legislators had essentially packed African-American voters into this district, and the district was challenged as a racial gerrymander. And the defense was, as you heard in one of Nina's cases in Texas, was no, this was not a racial gerrymander. It was essentially a partisan gerrymander. The Republicans were the Republican legislators were quite candid that their purpose in moving voters in and out of the district was to create a largely Democratic district, pulling Democratic voters from the surrounding districts. So this was challenged as a racial gerrymander in the district court, which was a 3-judge district court. The court struck it down as a racial gerrymander, and then it went up to the Supreme Court on direct appeal. So the question before the court was, what do we do with these cases where there's an allegation of a racial gerrymander, but the defense is that it was actually for partisan purposes? And so in some ways, the case started, it was relatively narrow. What the court held in a 5-3 decision written by Justice Kagan for Justice Breyer, Ginsburg, Sotomayor, and Justice Thomas. The court basically said there was no error below, that the district court had made fact findings. Those fact findings had showed that the intent of the legislature was actually race-based, not partisan, and those findings were upheld. Underlying that sort of very factual conclusion were a couple of legal conclusions that are sort of worth brief mention. One was that what the court held was that race could not be used as a proxy for parties, so that if you want, as a legislature, to disadvantage one party or another, you want to disadvantage Democrats, for example, you can't assume that all African Americans are basically going to vote Democratic, and therefore we're going to move African American voters in or out of a district in order to disadvantage a party. That is not a defense to racial gerrymandering. That is using race based on stereotypes and assumptions about how a particular group is going to vote. The court said you can't do that. And there actually wasn't much disagreement about that. The other thing, though, that came up in Cooper, which is, I think, more relevant, you'll hear some of the themes that echo into Gill, is there was a debate over whether, the debate was really, are claims involving a defense of partisanship going to be treated differently by the court? And the reason why this comes up is because they're very hard to separate. When you're trying to decide, is the justification race or party? And so what Justice Kagan said was, we're not going to treat these cases any differently. Yes, to be sure, they're hard, because from the court's perspective, some amount of partisan gerrymandering is okay. You're allowed to take politics into account in a way you're not allowed to take race into account. So some partisanship is okay. And what makes these cases hard is because there often is a high correlation between race and party in some parts of the country with some racial voting blocks. And so, and the other thing that makes it hard is that what we usually look for in a voting district to show animus, to show that the legislature was targeting, for example, African-American voters or Hispanic voters, the shape of the district, whether it's reaching out into different parts of the state, those indicators aren't helpful here, because the defense is, yes, of course we did that. But we did it to target Democrats or to target Republicans, not to target race. But what Justice Kagan said is, no, we're going to apply the usual rules. We're not going to have any special requirements. In this case, the particular requirement they were arguing over was whether the plaintiffs had to show that they could draw a map that advanced the political goals of the legislature but had less of an effect on race. And Justice Kagan said, no, that may be useful evidence, but we're not putting that in as a particular requirement. We're treating this case like we usually do racial gerrymandering. Justice Alito, writing for the dissent, took a much different tack. And what he said is, no, when you're talking about a defense of partisanship as a racial gerrymander, the court should be very skeptical and should hold the plaintiffs to a higher burden. And the reason for that, the reasons he gave were sort of threefold. First, he said the allegation that a legislature is targeting voters on the basis of their race is a serious accusation. The court has referred to it as a form of racial apartheid in some sense, and that's the kind of thing we don't charge a state with absent really good reason to think that. So we should make these claims hard to prove. Second, he said, it's an intrusion on a core function of the state. What he said was, when the court intrudes on the legislature, you have a court taking over a function that really should be part of the democratic process. And so the way he put it was, if a court mistakes a political gerrymander for a racial gerrymander, it illegitimately invades a traditional domain of state authority, usurping the role of the state's elected representatives. This does violence to both the proper role of the judiciary and the powers reserved to the states under the Constitution. So it's this idea that judges shouldn't be doing the redistricting, it should be legislatures. And then the third thing he said was that if we're not careful, if we, the court, are not careful, quote, the federal courts will be transformed into weapons of political warfare. And what he meant by that was that if you make it too easy to come in and allege a racial gerrymander, when in fact what was going on was a partisan battle in the legislature, the courts are going to be flooded with these things. And from Justice Alito's perspective, again, that would put both the court in a very precarious position, and it would intrude on what the legislature should be doing. So Cooper v. Harris sort of sets the backdrop for the kinds of worries that the court has about getting involved in partisanship. So let me turn now to Gill, which is really sort of the core of the case this term, and a very important case. The work that Nick and others are doing on this case is potentially transformative for the country, and so very important. So what's this case about? So again, the core thing that we're worried about in gerrymandering is packing and cracking. So packing is to put, for example, a lot of Democrats in one district, which creates one very strong Democratic district, but helps Republicans all around the district. I should say that, as Nina pointed out, this is bipartisan, although the Wisconsin plan is a Republican plan that disadvantaged Democrats. In Maryland, there's a Democratic plan that's disadvantaging Republicans. So it is bipartisan in that sense. Cracking, as opposed to packing, is taking voters from a district and sort of distributing them around. So, and Nina gave some examples of that, where you take a pocket of Democratic voters, you move it to an overwhelmingly Republican district, those Democratic voters leave behind a weakened district and have no influence or impact in their new district. So that's sort of what is alleged to have happened here. The districts at issue are in Wisconsin. It's a Republican-controlled legislature and governorship. And the districts were arranged so that following the redistricting, Republicans won 48.6% of the vote, so less than half of the vote, and got 60 out of the 99 seats, so a supermajority in the legislature. And so what the plaintiffs did then was challenge, the Democratic plaintiffs challenged that, and they alleged two things: that there was a violation of the Equal Protection Clause. You're discriminating against the voters of one party by preventing their ballots from giving them fair and effective representation, and a First Amendment violation, alleging that there was viewpoint discrimination, that you were punishing these voters for joining a party or for the way they voted. So the case comes up to the Supreme Court, and the question is, can the court even hear these kinds of claims? And so on the one hand, you say, well, why is that a problem? As Nina discussed at length, racial gerrymandering claims have been a part of the court's jurisprudence for quite a while, and the court seems to handle those quite easily. And so the question is, why should these be different? And the answer that comes back is there's a difference between race and politics, and that is the following. For race, the court is comfortable saying racial considerations cannot predominate in redistricting. It's just not appropriate. But for politics, they take a different approach. They say politics has been part of redistricting from the very beginning of our republic, and it's a natural part. And so the question with politics is not should we allow it or not, but has it gone too far? Is it too much? And that's the kind of thing a number of justices have said, and the state said in this case, that courts are just very poorly equipped to figure out. They can't figure out how much is too much. And that's where this case comes up. So one last sort of prefatory piece in this to set up the Gill case. The Gill case is building on a case that came before called Veith, which was heard in 2004 and was a partisan gerrymandering case. And in that case, it was a very interesting outcome for the court. All 9 justices to consider the case concluded that excessive partisanship in gerrymandering was unconstitutional. But 4 of the justices held that the court really couldn't do anything about it. There was just no way for a court to figure out how much was too much. 4 of the justices concluded that the court should be able to hear these claims, and 1 justice, Justice Kennedy, concluded that he needed more time. So these are the first slides. So the first slide just points out the 2 obstacles that Justice Kennedy pointed out to redistricting. And the first one we talked about is there's no substantive definition of fairness in districting, right? Nobody agrees on what it means to have a fair district. And the second one is that in the absence of rules to limit, that we need rules to limit and confine judicial intervention. We have to prevent judges from getting too involved. And what Justice Kennedy concluded, there's the hair trigger, is that he wasn't there yet. He wasn't willing to rule it out, as Justice Scalia's opinion for 4 members of the court concluded, and he wasn't ready yet to rule it in. And what he said was really sort of a very unusual thing for a justice to say was, there are weighty arguments for holding these things non-justiciable, partisan gerrymandering, but I'm not prepared to say never, and I'm not prepared to say never now. And those are the first 2 things that he described. He said, just because no standard has emerged in this case should not be taken to prove that none will emerge in the future. And then he laid down a challenge, which Nick is going to talk about how it was answered a little later, but it's very important to what Gill is about, where he talked about emerging technologies, and he said, these new technologies may produce new methods of analysis that make more evident the precise nature of the burdens gerrymanders impose on the representational rights of voters and parties. So again, laying down this challenge to say, I'm not convinced yet that judges can get involved in this sensibly, but maybe in the future they can. So why do we think? So Gill is very much about, and the work that Nick and others have done, is very much about meeting the challenge that Justice Kennedy put forward. So why might there be a different outcome this time? Well, one answer is that the social science research has happened, and you're going to hear more about that from Nick, so I'm not going to talk about that. The second thing, though, which is very important, is that the challengers are claiming there's a sense of urgency now, that technology has made redistricting even more precise, and with an increasingly polarized electorate, you can divide voters and know that for a long time, the boundaries you set up between Republicans and Democrats are going to stay stable. And so the result is a polarization in the legislatures. So you have situations in legislatures where the most liberal Republican is more conservative than the most conservative Democrat. We don't have any overlap between the parties. And so what you're doing is breaking up communities, and there's a loss of faith in the system. And so what the challengers are saying is democracy is really at stake, that what you have is legislatures choosing their own voters rather than the other way around, and that entrenchment prevents voters from doing anything about it, and the legislatures themselves don't have any incentive to do anything about it. And so the court, the plaintiffs would say, is sort of the last best hope. So what does the state say back? Well, the state says back sort of echoes of the debate that they were having, that Justice Kagan and Alito were having in Cooper, and that occurred in Veith, which is nothing really has changed. The basic problem hasn't been overcome. Justices and judges still can't figure out what it means to be too partisan or how much is too much. Second, that we should really be skeptical of everything Nick is about to say, that the social science data just isn't there yet, and the justices should be wary of it. Third, that court supervision is bad for democracy, right? We have a democracy. Legislatures should do the redistricting and voters should vote. It is not the job of courts to do that redistricting. And finally, that court supervision is bad for the court itself. That the court is going to find itself embroiled in political disputes more and more, and ultimately that's going to hurt the court. So they had oral argument on October 3rd, and these debates played out in an interesting way, and just as you might expect. And so some of these themes I hope will seem familiar. So Justice Ginsburg asked the question, if you can stack a legislature in this way, what incentive is there for a voter to exercise his vote? Whether it's a Democratic district or Republican district, using this map, the result is preordained in most of the district. What becomes of the precious right to vote? So very much invoking this idea that democracy is at stake. The right to vote, which is so central to our republic, is being undermined. The Chief Justice set forth the alternative concerns in a very powerful way. He said, and you can read it, but if the claim is allowed to proceed, there'll be a lot of claims like this raised around the country. We'll have to decide in every case whether Democrats win or Republicans win. And the whole point is you're taking these issues away from democracy and you're throwing them into the courts pursuant to what I can only describe as sociological gobbledygook. And the intelligent man on the street is going to say, that's a bunch of baloney. It must be because the Supreme Court preferred Democrats over Republicans, and this is going to cause very serious harm to the status and integrity of the decisions of this court in the eyes of the country. So what you see here is playing out in the Gill argument, two competing views of what it means to say democracy is at stake in these cases. On the one hand, Justice Ginsburg saying democracy is at stake because the right to vote is at stake. And the Chief Justice saying democracy is at stake because the whole legitimacy of the court and the legitimacy of the redistricting function belongs to the people and would be undermined by taking control of these cases. And so that's what will play out in the court's decision over the next few months. Thanks.
I guess I have my slides as well.
Yeah, it's ready to go.
I think you just hit go, yeah.
All right, excellent. Thanks very much again for inviting us here. This is a really terrific panel. So we heard from Ian about the law and the doctrine of partisan gerrymandering, and also about what transpired at the Whitford oral argument a couple weeks ago. What I thought I would do in my presentation is, number one, go over some of the empirical evidence that we presented in Whitford, and also in an even more recent North Carolina partisan gerrymandering trial that just concluded last week. And in the process, hopefully I can respond to some of the common misconceptions about our legal theory, and maybe also dispel Chief Justice Roberts' concern that this is all just sociological gobbledygook. And then second, I want to talk more briefly about what happens if we win in Whitford. So what kinds of lawsuits might we see in the future, and what sort of evidence would lawyers have to present in those cases in order to prevail? Before starting, let me just address one point that I thought Ian might discuss but didn't, which is just to lay out very clearly what the proposal is of the plaintiffs in Whitford. And so we're not proposing just that any particular metric be the dispositive tool for deciding whether a map is or is not a partisan gerrymander. Instead, we're advocating a three-part test involving 1, discriminatory intent, 2, discriminatory effect, and 3, a lack of any legitimate justification for this effect. So that means that before a plan could be struck down under our proposal, there would have to be evidence that the plan was enacted with partisan advantage as a motivation. There would have to be evidence as well that the map, in fact, has produced a discriminatory effect that is both large and durable, or likely to persist for the rest of the decade. And number 3, there would also have to be evidence that there's no neutral explanation for this large and durable effect. It's not due to geographic patterns. It's not due to a state's effort to comply with the Voting Rights Act or any other legal requirement. So that's the proposal. You know, it's not the efficiency gap, it's this three-part test that is the plaintiff's proposal in Whitford. So with that, let me turn to the efficiency gap, which Laura mentioned. So the efficiency gap is a quantitative measure of partisan gerrymandering that we've relied on in Whitford and also in North Carolina. The efficiency gap is rooted in the 2 techniques that Ian mentioned, the cracking and the packing of one side's voters. The key point here is that both cracking and packing produce what social scientists call wasted votes. So these are votes that don't contribute to the election of a candidate. In the case of a crack district, all of the votes that are cast for the losing candidate are wasted. You know, that candidate loses. In a pack district, all of the votes cast for the winning candidate over the 50% threshold that you need for victory are wasted. You know, that candidate would have won even without all of those extra votes above 50%. So the efficiency gap just takes one party's total wasted votes over all of the districts in a plan, subtracts from that the other party's total wasted votes, and divides that number by the total number of votes cast in the election. And so it tells you in a single number which party is benefiting from all of the cracking and packing in a district map, and to what extent that party is benefiting. Now, the next question is, okay, so we have this efficiency gap metric. How on earth do we tell what a big efficiency gap is? You know, this is the question that has bedeviled the court. You know, how do we figure out when something is too large to be normal and reasonable? Well, our answer in Whitford was to have our expert, Professor Simon Jackman, calculate the efficiency gap for every single state house map across America from 1972 to the present. And what Simon found was that Wisconsin's map, the map at issue in Whitford, is something like the 5th worst in modern American history as measured by its efficiency gap. It actually has a larger efficiency gap than any plan ever did before the current redistricting cycle. Similar analysis in our congressional lawsuit that we went through last week. Simon also calculated the congressional efficiency gaps for every plan from 1972 to the present. And he found that North Carolina's congressional maps this cycle have again been extreme historical outliers. The plan used in 2012 and 2014, that was at issue in Cooper, had the single largest average efficiency gap of any map in modern history. The 2016 plan that was used in the 2016 election had the largest single efficiency gap of any map in the country in 2016. So, how do we know when efficiency gaps are too big? Our brief answer is we can look at the historical distribution and compare challenged plans to that distribution. Okay, another question that comes up is, what is this newfangled efficiency gap thing, and how on earth are courts supposed to rely on a metric that was invented 3 or 4 years ago? And we have substantive defenses of the efficiency gap, but our other response is that, look, we're very open to the use of multiple quantitative measures of partisan gerrymandering. We cited multiple metrics in Wisconsin and in North Carolina, and we think it's perfectly reasonable for litigants to present evidence of multiple metrics and for courts to also cite multiple metrics in a decision. I'll only mention one other metric for now, which is called partisan bias. This was the most well-established metric prior to the development of the efficiency gap. And partisan bias asks, if you had a hypothetical, perfectly tied election, what would the difference be between each party's share of seats in the legislature and 50%? That difference is defined as partisan bias. So what do we find with partisan bias? I only have a slide for North Carolina here. We find the exact same thing that we did with the efficiency gap. So when you look at the historical distribution of partisan bias in congressional elections from 1972 to the present, North Carolina, again, is a radical outlier. In fact, it's the second worst of all time, according to these partisan bias calculations. So, if you don't like the efficiency gap, if you prefer the more well-established, more familiar partisan bias metric, well, it leads to exactly the same conclusion as the efficiency gap. There's a catch, however, with partisan bias, which is that it can't be used in uncompetitive states. So partisan bias works in a place like North Carolina, it works in a place like Wisconsin, because in those competitive states, the hypothetical tied election that you need to calculate partisan bias is not that speculative. It's not hard to suppose that Wisconsin or North Carolina might have a perfectly tied statewide election. But that's a really remote possibility in a state like Utah or Massachusetts. And so the metric doesn't work in those states. And you can see here, because of the unreliability of partisan bias in uncompetitive states, it's only loosely linked to the efficiency gap in those states. And on the other hand, in competitive jurisdictions like Wisconsin and North Carolina, there is almost an ironclad relationship between the two metrics, and they tend to tell the same story. What that means is that in competitive places, it's fine to use multiple metrics, but only the efficiency gap is really robust and workable in uncompetitive states. Let's see where I am. Okay, so another concern that came up over and over in both of our litigations was, well, how do you know the observed efficiency gap or partisan bias that you saw in one or two elections? How do you know that's not a fluke? You know, people change their minds from year to year, issues change, candidates change. So how do you know that a map that was really biased in the elections that you've seen will remain skewed over the lifetime of the plan? And our answer here is a social science technique known as sensitivity testing. The idea with sensitivity testing is that you take the observed election, that's the very middle of the chart. That's where it says 0, right in the center. And there you have the observed, let's say, efficiency gap in that real election. You then start shifting the statewide vote by 1 point, 2 points, 3 points, 4 points in each party's direction. And you recalculate the efficiency gap for every one of those other potential electoral environments. And that gives you a pretty accurate sense of how the map would perform if there was a small swing, a big swing in either the Democrats' or the Republicans' favor. And what this testing shows in Wisconsin is that even if Democrats improved significantly on the 2012 outcome, the map would continue to exhibit really big, really pro-Republican efficiency gaps. In this chart, I think the plus sign refers to Democratic swings, and the minus sign refers to Republican swings. So this map's Republican advantage is basically impervious to swings over time. That's how we know that this is a durable Republican gerrymander. Same sort of analysis for North Carolina with even bigger swings, this time with 10-point pro-Democratic and 10-point pro-Republican swings. It would take you in North Carolina something like a 10-point pro-Democratic swing in order for that plan's pro-Republican advantage to evaporate. We've only seen a pro-Democratic swing that big once in the last half century. That was 1974 in the Watergate election. So basically, Republicans are going to keep benefiting in North Carolina unless we have another Watergate, which is possible. You know, one doesn't know. We really can't rule that out. But that's what it would take to flip the advantage in that map. Okay, yet another criticism that we often get, and that I alluded to earlier, is how do we know these large partisan advantages are due to deliberate gerrymandering? How do we know that they're not the result of political geography, right? I mean, everyone knows that Democrats tend to be clustered in urban areas, and that you have heavily Republican exurban and rural areas. How do we know those spatial patterns aren't responsible for the asymmetries that we're observing? And also, how do we know that the asymmetries aren't being caused by Voting Rights Act compliance, or an effort to draw compact districts, or an effort to keep counties whole or keep municipalities whole? And so here, this is the final social science method that I'll talk about. I think the gold standard is to use a computer, instruct the computer to generate for you hundreds or thousands of alternative maps without considering any electoral data whatsoever, and also instruct the computer to keep just as many or more counties and municipalities whole as the actual plan, to draw just as many districts that are required by the Voting Rights Act, to draw districts that are just as compact, just as equal in their populations, and then see what happens. So if the political geography of a state really is benefiting one side or the other, that should be evident in the hundreds or thousands of simulated maps. But if the actual plan is an outlier compared to the simulated maps, that tells you that the actual plan's bias cannot be justified by political geography or by any nonpartisan redistricting goals. So what do we see in Wisconsin with this? Well, we see that the simulated maps all tend to have quite small efficiency gaps. In fact, all of their efficiency gaps are within just a couple of points of zero. None of the simulated maps ever even approaches the enormous pro-Republican skew of the actual plan. And all of the simulated maps are also better than the actual plan in terms of traditional criteria, like keeping counties whole. So, we don't know what would be true in all states, but we know in Wisconsin that political geography and traditional criteria are not the explanation for the efficiency gap that we've observed. North Carolina, exact same result. There, the simulated maps again have small efficiency gaps. If anything, the simulated maps in North Carolina tilt a little bit in a Democratic direction. So we have a state that, as far as we can tell, has a somewhat pro-democratic political geography. Nevertheless, we're getting one of the biggest Republican efficiency gaps of the last 50 years. So we know that big Republican efficiency gap is not explained by the geography of North Carolina or by any of the other legitimate redistricting goals that North Carolina was trying to achieve with its map. Okay, I think that's it for my empirical evidence. The last thing I want to talk about is, well, what happens if we win? So let's say the Supreme Court endorses something like our proposed test in Whitford. What happens then? This will, wow, that's not how the slide was supposed to look, but let's see. Okay, well, I guess this is really blown up. I'll just say, and you're missing the rest of the slide. So very quickly, it won't be easy for plaintiffs to win using our theory. Number one, they have to show discriminatory intent. So you can rule out, for having there be any real prospect of liability, just about any plan that was created by a court, by a commission, or by divided government. It's very implausible that partisan advantage would be a motivation for a plan like that. Number two, you need a really big partisan asymmetry. So partisan efficiency gaps, partisan biases that fall around the middle of the historical distribution, they won't be enough. You need a really extreme, big score by historical standards. Number three, you also need to prove the durability of the plan's partisan advantage. So if it turns out that a map has a lot of competitive districts, and so therefore, even if there was a small shift in the statewide electoral environment, the big efficiency gap that you observed would dissipate or evaporate, again, you lose. In that case, you haven't demonstrated a large and durable partisan advantage. And lastly, the district map simulations would also have to confirm that the efficiency gap you see is a lot bigger than the one you would expect given the state's political geography and nonpartisan redistricting goals. So I think Chief Justice Roberts is wrong to think that the plaintiff's test would somehow imperil the vast majority of district maps around the country. So our best estimate is that only a handful of congressional maps and only a handful of state legislative maps would be seriously vulnerable under our test. This is not another 1960s style reapportionment revolution where all of a sudden every map in America is unconstitutional. It's nothing like that. Very last thing I'll talk about is, again, let's say we win. At the moment, we have a whole bunch of enacted maps. And so we have a lot of data on how those enacted maps have actually performed in observed elections. But what happens in 2021 when states start drawing a whole bunch of new maps. First of all, can you use the efficiency gap or any other metric prospectively so that we have some sense of what's allowed or what's not allowed before an actual election comes along? And the answer is you absolutely can do this. This is just one quick example that the Campaign Legal Center put together. North Carolina recently passed a new state House map and a new state Senate map. These maps have not been used in any election yet. They were drawn earlier this year. And yet, using an aggregate of prior election results, it's possible to estimate what these plans' efficiency gaps will be and what efficiency gaps they might exhibit over a wide range of possible electoral environments. Now, we don't know exactly which scenario will materialize, but we can very safely say now, before an election, that these are extremely pro-Republican maps and extremely durable in their Republican advantage. And we know all of that prospectively before an election. And I'll note that there's a website that I'm currently working on that's not up and running quite yet that will hopefully allow people soon to upload any district map. And the website would then spit back at them something like this. And so it would show them these are the anticipated partisan implications of a district map even before an election has occurred. So in a world where we win in Whitford, this kind of information is going to be invaluable to legislators, to the media, to potential litigants. And so I think it would be very helpful to have this be easily available to everybody and not something that's only generated if you can afford your own political scientist expert. So with that, I'll stop, and I'm looking forward to hearing everyone's questions. Thanks a lot.
All right, Nick. So Nick, Ian mentioned that this is a bipartisan problem. Are your techniques being used to challenge any districts that go in the other direction?
Yeah, absolutely. So, because 2010 was a huge Republican wave year, Republicans won control of redistricting in a whole lot more states this cycle than Democrats have. And so we currently have a lot more maps drawn by Republicans and benefiting Republicans than we do maps that were drawn by Democrats and benefit Democrats. But there are Democratic gerrymanders right now in states like Massachusetts, Maryland, Rhode Island, et cetera. And I've talked to people in those states, and I think lawsuits on this kind of a theory are perfectly viable in those places. And historically, there are any number of egregious Democratic gerrymanders that would fail all of the different prongs of the test that I laid out.
Are any using it now?
Yeah, the three states that I mentioned all are
using your standards in litigation.
Well, as a full-time law professor, there's only a certain number of cases that I can work on directly, and I think I've already exceeded my own personal capacity. But I certainly think that lawsuits could and should be brought in Rhode Island, Massachusetts, Maryland, at least, on this kind of a theory.
Okay. Ian, when you were mentioning the prior case, the Veith case, all 9 justices agreed with the idea that there was a constitutional problem. But the court has changed a fair amount since 2004. So what can you tell us about what you might expect from the newer justices who have joined the court?
So I don't think that there's going to be much disagreement on that core point, because even in 2004, of course, it was Justice Scalia and Justice Thomas joined the opinion, obviously Justice Kennedy. So on the core question about whether excessive partisanship itself is unconstitutional, I wouldn't expect the court to sort of disagree with that. The question of what the justices will do, whether Justice Kagan and Justice Sotomayor, who are new to the court, and then Justice Gorsuch and Justice Alito, where they would be, on the justiciability point, we just don't know until they they actually vote. There is a sense among the groups following this that the case is likely to come down again to Justice Kennedy, and so all eyes certainly were on Justice Kennedy. And I think it seems very likely that where he goes, there's a very good chance he'll be able to bring a majority of the court should he decide to decide the question one way or the other.
What about his questions during the oral argument? Did he give any hint of where he's headed? So
I think it's always dangerous to read oral argument, too much into oral argument. But the one question that I think, that he asked that got a lot of attention, and rightfully so, is he focused a little bit on standing right out of the box. And so there's a question about whether the plaintiffs have the right plaintiffs to be challenging it and under the right theory. They are challenging the plan on a statewide basis. And in the racial gerrymandering context, you can't generally challenge a plan on a statewide basis. A voter can only challenge the district in which that voter actually votes. And so there was a lot of discussion at the argument about whether the rules were different for a partisan gerrymandering claim. Would it matter whether it was a First Amendment claim or an equal protection claim? And those kinds of discussions happened. The reason why it's so significant is because if Justice Kennedy were to be hesitant again to either foreclose or endorse a justiciability theory of the kind that the plaintiffs have put forward and that Nick has so well explained, standing provides him a mechanism to resolve the case without resolving that issue. And so it got a lot of attention when after Justice Kennedy raised the question. Justices across the spectrum followed up, and so I think there'll be a lot of attention paid to what ends up happening on standing.
Okay. Well, Nina, can you talk a little bit about what's the, or if you have a view on what's the sound reason why racial gerrymandering has to be challenged by someone in the specific district, but that might not be the case with partisan gerrymandering. The named plaintiffs, am I right, Nick, weren't, there was one from Madison, was going to be a Democrat in Madison, pretty much.
I think Nick may be the better person, or Ian, because one, I don't do partisan gerrymandering cases, but I know the rule well that if you're going to challenge a racial gerrymander, you have to live in the district that you're alleging is racially gerrymandered. And reading the transcript, there was at least a little bit of focus on the idea of if you're a Democrat in a Democrat district in Wisconsin, what's your beef, basically? Where's your standing?
Yeah, I'd say a couple of things that, I guess, what's your beef? What is Bill Whitford's beef? His beef is that statewide, the electoral influence of all of the Democrats in the state of Wisconsin has been undermined by the pro-Republican partisan gerrymander. Nothing about our theory hinges on district-specific representation. The entire crux of the case is collective statewide representation for members of a particular party. And I think there's clearly not support for our view of standing in the racial gerrymandering cases, but there clearly is support in what I think are the more analogous one person, one vote and Section 2 VRA cases. So in a one person, one vote challenge, any single plaintiff who happens to live in an overpopulated district has standing to challenge all of the malapportionment of the entire statewide district plan. That's how it's worked for 50 years, standing in the one person, one vote context. And I think it's a very close analog to the partisan gerrymandering context. So, just as any single resident of an overpopulated district has standing in one person, one vote cases, any member and any supporter of the disadvantaged party would have standing in a partisan gerrymandering case. The other even more direct analog, I think, is the Section 2 analog. So there, a minority voter can absolutely have standing, even if that minority voter is already represented by the candidate of his or her choice in his or her own district.
Can you give a quick thumbnail on what the Section 2 VRA claim?
If you want more opportunity districts to be drawn in a given region.
You have to live in a diluted district in order to
Not
have
a PAC
standing.
district? I mean, a packed
Right,
district is
diluted, right, packed or cracked, but you can't be in like a non-dilutive district.
you have to live in an area where additional opportunity districts could be drawn, right?
You could say that. That's not always the case, but you could say it that way.
And to be fair, the Supreme Court, I think, has never been exactly clear about how standing works in the Section 2 context.
Can you, before
Yeah,
can I
sorry,
pause and just like explain what a
I
section 2?
could let Nina
All right, please.
This may be my only chance. This is back on the Voting Rights Act and vote dilution. You don't have to be in a racially gerrymandered district in order to have a claim under the Voting Rights Act, or it would be a very broad understanding of racial gerrymandering. You remember how I showed you a map where Latinos living in Fort Worth were taken and scooped out of Fort Worth and brought up and combined with a much larger group of Anglo voters in Denton County. And in that situation, the Latino voters, because of polarized voting, their vote is always outweighed by the larger group of Anglo voters in Denton County who are voting for a different candidate. And so in that situation, if there were enough Latinos down there in Fort Worth to make a Latino majority district, the fact that they were getting scooped out and sent to a place where they were in the vast minority is a vote dilution violation. So that's an example of cracking. And then you can also have the opposite, which is smushing together so many Latinos, like a 70 or 80% Latino district, that you're depriving the ability to draw a second Latino district. So there's both the packing and the cracking. If you're going to have standing to bring those claims, you have to be in the district that is either packed or cracked. For a straight up, what you call a disparate impact vote dilution claim. On one person, one vote, because I just worked on the Evanwell case in the US Supreme Court, your standing again is based on being in a district that's overpopulated in a one person, one vote case. So again, the idea is that you're living in a district where your personal vote is somehow being affected by the line drawing. In the case of Gill v. Whitford, I don't think he has an argument that his personal vote is somehow diluted or affected, but it's almost an argument that he's sort of unable to combine his votes with others that seems to be the source of his injury.
And I think that's similar to the other context that we talked about, where the resident of an overpopulated district is electing his or her preferred candidate in that district. You know, if all we cared about was district representation, that plaintiff ought to be perfectly happy where they are. And yet the harm, though, is that because of the overpopulation, their vote isn't having the same impact collectively and statewide as it would under a non-malapportioned plan. I mean, in my mind, the most important point about standing is that across the redistricting, the different redistricting domains, it's basically derivative of the legal theory. So you always have the kind of standing that makes sense given the legal theory you're advancing. And so if you're bringing a racial gerrymandering challenge, where the argument is that a particular district was drawn for predominantly racial reasons, then it stands to reason that only members of that district have standing. In a one-person, one-vote claim, where the legal theory is statewide malapportionment, then standing also extends to challenging the plan on a statewide basis. So my view is you can't really separate the standing question from the merits. And standing will follow. Standing will be derivative of what kind of partisan gerrymandering theory the court is willing to recognize.
How about third parties? How do places where you don't have just two main contenders, how does that system fare with the efficiency gap structure?
Yeah, so it's not hard to extend the efficiency gap calculation to the multi-party context. My co-author wrote a short piece where he explained how to do this. The basic idea is that you have two focal parties for the calculation, and you group together all third-party votes and seats and treat them as a sort of lump other. and then you calculate the efficiency gap for the two focal parties. Those two focal parties don't have to be Democrats and Republicans. You could calculate an efficiency gap for Republicans versus Greens, or for Democrats versus Socialists, or pick whatever pairing you want. The key is just that for the efficiency gap, or for any of the other metrics, you need to focus on two parties while aggregating all the other parties. In practice, given that third parties win tiny shares of the vote and even tinier shares of the seats, this is largely irrelevant for most American jurisdictions.
Ian, I think you said that it looks like this might be an equal protection. You can go equal protection lane. You could go in the First Amendment lane. How do you think the rule, if one comes out, will be adjusted depending on which way they go? Will you follow the traditional First Amendment test of does this district fit within the jurisprudence relating to First Amendment burdens, or would this be a new standard on its own along the lines of what Nick is suggesting?
So I guess I think that, first of all, if it comes out the way that that plaintiffs have hoped, that it's likely to be a First Amendment kind of analysis, that Justice Kennedy and Veith expressed the view that, at least his own view, that the First Amendment approach was stronger, and it seemed, at least in what he's articulated so far, that the way he's conceptualizing or at least the way he did in Veith, was to think about it as a First Amendment violation, that this is really best thought of as punishing voters for the association that they've had and the votes that they have cast. And so I think we're likely to, to move along that line if Justice Kennedy sort of continues to think about it that way. Once that happens, I'm not sure that it requires any revolution in the court's jurisprudence. I mean, if the court is able to satisfy itself that it's manageable and that it's, the three-part test that Nick articulated, supplemented by the kinds of social science data that he's explained, is sufficient. I think it fits within the kind of general First Amendment jurisprudence that you can't punish voters for the way they voted, you can't punish people for the parties that they've joined. And so I don't think it requires, like the First Amendment side, a real substantive rewrite of the court's jurisprudence.
Okay. One thing that we've seen from Chief Justice Roberts is a strong, nearly protectionist view of how the court is viewed in society. And that comes through in many of his questions and many of his opinions. And I think that question about the intelligent man on the street reflects that concern about how the court will be viewed. These cases are these are not certiorari cases. These are automatic rights of appeal to the Supreme Court. To what extent, if any, do you think that is going to impact the way these cases come out versus if they were the discretionary review cases, like most of the cases on the court's docket?
No, jump in on that. I think the court seems to care a lot about whether cases are regular certiorari cases or direct appeal cases. At the same time, the court disposes of many, many redistricting cases through summary affirmances or occasional summary reversals. So I think initially, while the doctrine is being worked out, the court would probably have to consider a number of follow-up partisan gerrymandering cases. I think down the road, in a few years' time, the court ought to be able to dispose of a lot of partisan gerrymandering cases via summary dispositions, the way that it currently disposes of lots of other redistricting cases. Let me just also note, Chief Justice Roberts' comment about the intelligent man on the street is nearly verbatim what the dissenters warned about in the one-person, one-vote cases 50 years ago. You had Justice Harlan and Justice Frankfurter saying the exact same things, that if the court wades into this difficult area, the court will undermine its own legitimacy, the court's actions will start to be seen as overly political. And their dissents were very eloquent back in the early 1960s, and they were also basically very wrong. So very quickly, the court came up with a doctrine that was manageable and widely accepted. Pretty quickly, the reapportionment revolution was over. If anything, that chapter in the court's history is considered a great success. The court intervening and ending one of the most undemocratic, distorting practices in American politics. So I think, to the extent we can draw any lessons from the last time the court was called upon to do something a lot like this, none of Roberts' fears materialized. And in fact, the court grew its capital as a pro-democratic, small d, institution in American life.
Nick, under your test, would having bipartisan creations kind of give a force field of protection on any district that is created, even if that bipartisan is itself an unbalanced commission?
So I do think if you have both parties agreeing on a map, and that map is a pretty bad map, it insulates a bunch of incumbents, it's a pretty uncompetitive map, I wouldn't like that map at all, but I would say it's not vulnerable to a partisan gerrymandering challenge. For better or worse, the court has had no interest in recognizing a bipartisan gerrymandering theory. You can imagine a theory like that, but it's not one that currently has any doctrinal support. So we're taking the existing precedent as we find it, which is only recognizing a partisan theory. So yeah, I think there would be a force field around that kind of a map.
Okay. And one of the questions that came up in the Whitford argument is isn't the efficiency gap just a nicer way to talk about proportionality? And proportionality is one of those things that sounds good at first, but it's been soundly rejected, and it's not a viable theory anymore. But is the efficiency gap really just proportionality with a different name? And if not, why not?
Yeah, I mean, it's literally, arithmetically different. So proportional representation has a meaning, which is that a party's seat share equals the party's vote share. That's what it means to have proportional representation. When we say that, Israel or Germany or the Netherlands has proportional representation, that's what we mean. They have an electoral system that guarantees that parties' seat shares equal the party's vote shares. So the efficiency gap, simply doesn't work that way. You tally the parties' wasted votes district by district, you compare them, you divide by the total number of votes cast. This is an aggregate, the efficiency gap is based on aggregating wasted votes district by district. It's simply not computed at all by comparing a party's vote share to a party's seat share. And moreover, it turns out that maps that are perfectly proportional have large efficiency gaps, and vice versa. Maps that have zero efficiency gaps are quite disproportionate in their votes and seats. And that's because the efficiency gap is designed to work with a single member district system like ours, which is not supposed to. It's not meant to yield proportional representation. And so the efficiency gap is consistent with the kind of system we have. It's not consistent with a European-style proportional representation system.
Interesting. Do all of the things we've been talking about have been largely in the context of the congressional districts? Do these principles apply equally in state districts? And if not, how are they different?
Well, Whitford is actually the state redistrict.
That was a terrible question.
That's fine. No, but it is. As Nick pointed out, though, he's got it for both. And so I think it is, it is for both. And so I think you see the kind of redistricting that you worry about in partisan redistricting. You see it in state races. You see it in federal races. It's when the legislature controls it, and I think it's equally the same.
I think if anything, it's more complicated at the congressional level because there's an interstate aspect to it. You know, do we really care if North Carolina has a Republican gerrymander? If hypothetically we were in a world where 20 other states had big Democratic gerrymanders, maybe we'd care about the distortion of a congressional delegation. But a congressional delegation is just a subpart of the U.S. House of Representatives. So some of those interstate concerns are really quite tricky, and they don't come up at all in a case like Whitford, which is just about a single self-contained state legislature.
Okay. Well, do you all have questions? I'm sure. Can you come up and ask at the recording so we make sure that the people who watch on video will be able to hear? Right in the center. That's why I didn't say anything.
So Chief Justice Roberts used the word gobbledygook, and how did the opposing side try to attack or undermine the social science, data, and were they effective at all in doing that?
Yeah, I think they tried, death by 1,000 cuts. They didn't have a single central criticism. They just had, 100 small criticisms. They don't like the imputations for uncontested races. They don't like the volatility of the efficiency gap because its value can change from one election to the next. They don't like the fact that sometimes you have clear partisan intent, but it doesn't that intent isn't effectuated with a large efficiency gap. They raise the proportional representation argument. So I don't know at this point what they think their central critique is, but they had just a lot of individual efforts to undermine the social science. It's hard to say which of those are effective and which are ineffective. As somebody who's steeped in the empirics, I think that there are good responses to all of these challenges, but which challenges might seem persuasive to a generalist judge, I don't really know. I'm curious if Ian, you have an intuition as to which of these critiques have some bite.
Yeah, the things that they said, a couple of things. The bigger challenge I think that they've made in some ways is to the whole approach. They, one theme of the defense of the position for the state is that where in the Constitution do you see these kinds of requirements? Like what in the Constitution says if you have a 7% efficiency gap, that's enough? And so in some ways, part of their analysis, and a big part, is that you're asking the court to constitutionalize a set of data requirements that should give us pause, they would say. And so a lot of the attack is sort of at that level. I don't know, one thing, Nick, that might be worth talking about is they do allege that there's, and you touched on this a little, but they do allege that there is a pro-Democrat bias because more Democrats are concentrated in cities. And so that was something they made very explicit, and I don't know whether you want to talk about the response to that.
Yeah, the argument's not that, the metric, of course, is just arithmetic. Like, there's no way that, the arithmetic of wasted votes inherently favors, Democrats or Republicans or, green or purple voters or anybody else. It's just arithmetic. The argument seems to be that Democrats are more concentrated in cities than Republicans are anywhere else. And so therefore, if you draw maps without any partisan intent, you're naturally going to end up with pro-Republican efficiency gaps. And the observed scores are not capturing what portion of the efficiency gap is due to intentional gerrymandering, as opposed to just being the impact of political geography. So for example, you see a negative 10% a pro-Republican efficiency gap. That looks really big, but if in the absence of any problematic intent, you would have still ended up with a 7 or 8% efficiency gap, then maybe we don't think that's nearly so problematic. And maybe 10% pro-democratic efficiency gaps, those are even more distant from what you would expect given the country's political geography. And yet, if you score these things at an absolute level, you're not taking into account any of those spatial considerations. So I think that's the argument. And there's maybe there's a lot of responses. One response is that, in fact, if you look at efficiency gaps over a 50-year period, they are not skewed in a Republican direction. It is a perfect bell curve that's centered exactly at zero. And over a 50-year period, you have every bit as many large Democratic efficiency gaps as you do large Republican efficiency gaps. So there is no evidence in the historical record of a pro-Republican political geographic skew. The second response, I'll just stop with that one, is that political geography is the most important factor that we're testing for in the third step of the test. So, if you have a big Republican efficiency gap, and that's just because Democrats really are all clustered in Chicago or in New York or Miami or pick your state or city, then the simulations will pick that up, and then the actual map won't be an outlier compared to the simulated maps. It'll fall right into the distribution of simulated maps. So because of that third stage, which the other side sort of ignores, there's no danger of finding liable maps whose large biases are the product of political geography and not of deliberate gerrymandering.
Any other questions?
Maybe I missed this the last time you all convened, but I'm wondering whether you've mentioned political and race or ethnicity-based gerrymandering. I wonder if there's a third wave, and that could be based on the prior condition of servitude, particularly given if you believe statistics from a fifth to a third of black males in this city, for instance, have been through the criminal justice system and are therefore ineligible to vote. Is there an issue there that could be raised in terms of the concentration of ex-felons in the certain districts? And I think, as an aside, I think that became an issue the last time the Chicago aldermanic districts were drawn in, 2012, 2013.
Well, if you all are trying to get an answer to that one. I'm
sorry?
Well, I was saying, while they're working on an answer to that one, I wanted to let you know that the third in our series on the Voting Rights Act, which I think is going to be in the new year, is going to be talking about some of those issues, not in the context of gerrymandering, because I really want to hear that answer too, but just generally the topic relating to impediments to voting, including felon disenfranchisement, is something to keep an eye out for. I think that's going to be in a coming panel. But on the gerrymandering overlaid with the felon issue, I'd love to hear your thoughts.
Well, that was my first answer, was that there are other ways of making it harder to cast an effective vote. A very sophisticated ways through gerrymandering when people are voting, but you're figuring out ways to dilute their voting strength. But there's certainly a lot that you can do on the front end to prevent people from registering at all. And that includes laws that disfranchise people either temporarily or permanently upon criminal conviction. The only thing I would say with respect to redistricting is that there have been attempts to draw districts instead of based on total population, which is what we all pretty much think the Supreme Court has told us to do, instead of drawing districts based on total population, to start looking at eligible voters, right? So somebody with a felony conviction in a state that permanently bars you from voting wouldn't count towards the total number of people in the district if you were just drawing based on eligibility. And this would largely also tend to dilute the vote of people in places where there are lots of children, because children aren't eligible to register to vote, and also people who live in and among non-citizens who are themselves citizens would end up with a very diluted vote. So there was an attempt in the Evanwell case, which I mentioned earlier, to try to get the Supreme Court to say that districts should be drawn just on the basis of eligible voters. And that would have had an extraordinary, amazing awful impact on pretty much every state in the country, and the court was having none of it, which was great for us because we were on the side of wanting to count everybody in election districts.
All right.
So I have a question is, suppose it were possible to easily draw, let's say in a state with 10 districts where a very small change would flip all of the districts. Could a state say, well, we could do that, it would be easy, but we'd rather have a system where a 1% swing only swings one seat, and so that we have, I guess, stability or something would be their theory. Is that a legitimate consideration that a state could use?
I think it's preferable for a state to draw a district map that way, because I think people would find it, problematic if a state swings from 49% Republican to 51% Republican, if suddenly the congressional delegation goes from 0 Republicans to 100% Republicans. I think that that kind of winner-take-all aspect for a legislature strikes a lot of folks as problematic. That's the basic reason why 150 years ago we shifted from statewide at-large elections for Congress in many states to districts. It was to get away from that winner-take-all aspect of at-large elections, and the having every single district be right at 50-50 is a way for a districted system to basically recapture the winner-take-all characteristics of the old at-large systems. So I think that it's highly preferable not to adopt a map where every single district is 50-50.
Well, if every single district was 50-50, would that be more efficient or than a gradient district?
That kind of a map would be prone to giving you extremely large efficiency gaps, but also extremely volatile efficiency gaps. So, as you go from 49% to 51%, you'd have an efficiency gap that swings radically from favoring the other party to favoring that party. And so I think none of these are good characteristics for a statewide district map.
Okay, thank you.
Okay, and we'll have this be our last question. And then I just want to encourage everyone to make sure you sign up for your CLE credits, although I'm sure that's not why you're here, but it's a nice benefit. And then also we'll have some refreshments outside.
There was a term that came up during the Whitford oral argument for the Supreme Court, partisan symmetry, and in fact, a number of the justices raised it, and it was part of a standard that Justice Breyer had sort of tossed out and asked the parties to respond to. Can you explain what partisan symmetry is and how it relates to proportional representation?
Is that a question for me? Okay. This is from Doug, who's one of my co-counsel in the case. So I'm not sure why he's quizzing me on this. Haven't we discussed this, in other settings? So partisan symmetry is the broader concept that the plaintiffs are arguing for in Whitford. The efficiency gap, partisan bias, those are particular metrics, but they all fall under the umbrella of partisan symmetry. Partisan symmetry means that a district map is treating both parties' voters symmetrically, in that both parties' voters have a roughly equal opportunity to translate their ballots into legislative representation. So the efficiency gap, partisan bias, these are all particular ways of encapsulating or capturing the broader notion of partisan symmetry. And then partisan symmetry is not proportional representation for some of the reasons we've talked about already, that none of the measures of partisan symmetry are equal to a one-to-one seat-to-vote relationship. And more broadly, you might say that a map is perfectly symmetric if it allows one party to convert 55% of the vote into 60% of the seats. As long as if the other party won 55% of the vote, it would also win 60% of the seats. That's clearly disproportionate. 55% is not equal to 60%. But yet, that is the very definition of partisan symmetry. Both parties are treated exactly the same in the scenario where they win 55% of the vote. that's just one illustration of why symmetry is a quite distinct legal and social science concept from proportional representation. So hopefully that's what I said in private as well.
All right, well, thank you to the panel. Thank you all for coming.